A recent decision highlights the importance of carefully writing and understanding agreements. It involves non-disclosure agreements. Businesses use non-disclosure agreements in many situations. For example, mergers and acquisitions, to obtain expertise of third parties for development of new technologies, and to test products with third parties without publicly disclosing the product. In all these examples, the purpose of the NDA is to protect trade secrets and confidential information. These agreements must be carefully worded or you could lose your trade secrets and confidential information. Blade Room learned this the hard way. Because of the language in their NDA, which they drafted, they lost a $60 million judgment and $18 million in attorney and expert witness fees. Here's what happened. Blade Room and Emerson Electric are competitors. They're involved in designing and building data centers. Emerson was interested in purchasing Blade Room, and in 2011, they signed an NDA. Of importance was paragraph 12 of that NDA. It provided, the parties acknowledge and agree that their respective obligations under this agreement shall be continuing, and in particular, they shall survive the termination of any discussions or negotiations between the company regarding the transaction, provided that this agreement shall terminate on the date 2 years from the date hereof. That last language was the killer. Provided that this agreement shall terminate on the date 2 years from the date hereof. The acquisition fell through. A year later, the two were competing for a contract to develop a data center for Facebook. In 2014, 3 years later, Emerson was chosen by Facebook. Blade Room later discovered that Emerson used their trade secrets. In 2015, they sued Facebook for copying its technology and Emerson for breach of contract and misappropriation of trade secrets. Blade Room settled with Facebook, but the trial continued against Emerson, and Blade Room won. Emerson appealed, arguing that the NDA ended in 2013 and any disclosure after it terminated wasn't appropriate. The Ninth Circuit Court of Appeals agreed. The court found that the language, provided this agreement shall terminate on the date 2 years from the date hereof, meant that any disclosures after termination were not subject to misappropriation. Emerson was free to use what it learned during due diligence after the 2-year period expired. Blade Room argued that paragraph 12 referred only to the actual discussions and negotiations between it and Emerson, that these terminated after 2 years, not Emerson's confidentiality obligations, but the court pointed out that the agreement stated this agreement shall terminate, not that discussions or negotiations shall terminate. Non-disclosure agreements are not boilerplate commodity agreements. As this case illustrates, they must be carefully drafted. In fact, I suggest once drafted, somebody else knowledgeable about these types of agreements closely reviews it for any potential issues. There's a link below to schedule a time if you want to discuss any of these points further. Thank you for watching.